Hello, my name is Lee Presser. This is my show. I speak frequently to very interesting people. Some of these conversations are so exciting, so intellectually stimulating, I thought others might like to listen in. This is the reason we started recording Conversation with Lee Presser.
Welcome to Conversation with Lee Presser. Today we're going to discuss legal protections of intellectual property. Best known in that group is copyright. Copyright are exclusive rights granted to the author or creator of an original work, including the right to copy, distribute, and adapt the work. Copyright owners have the exclusive statutory right to exercise control over copying and other exploitations of the works for a specific period of time, after which the work enters the public domain. Another protected property is trademark. Trademarks serve to identify a particular business as a source of goods or services. Certain exclusive rights attach to a registered mark, which can be enforced through legal process. Our guest today, Yvette Liebesman, is an assistant professor of law at St. Louis University, where she teaches intellectual property law. Prior to joining St. Louis University, Professor Liebesman practiced law in the intellectual property transactional group at Ropes & Gray, LLP in Boston. Yvette Liebesman, welcome to Conversation.
Thank you very much.
So let's just start at the beginning. What is intellectual property?
Well, intellectual property in the broadest sense is information. It's known as a public good. And what that means is that the resource is inexhaustible and anybody can use it at any time. It's not going to affect others. And it's not like you can put up a fence and stop people from walking onto your land. Anybody can use it unless you have legal protections. So in that sense, unless we have a law that says you can't do certain things with someone else's art, anyone would be free to copy it. So it's a matter of legal protections versus, like I said, putting up a fence to keep people off your property.
Mm-hmm. How did this come to be that people thought that they had the right to own their own property, their own intellectual property? Because at one time, I suspect that the king or the head man or whoever, he owned everything.
Well, it actually goes back very far. There's about 500 years ago, there was something called the Statute of Anne, which first passed in England. And what that did is it was the first time that gave publishers exclusive rights to print books. And when in this country, in our Constitution, Article 1, Section 8, Clause 8, it talks about saying that Congress has the ability to make laws that will protect artists and authors and inventors the rights for a limited time, the exclusive rights to their works. So it goes back to 1783 when our Constitution was first written.
Most countries during that period did not have those kind of protections, did they, for individuals?
They didn't, but not too long after, by the 1800s, there was something called the Berne Convention, and countries grew and grew and grew. The Berne Convention was passed in the 1880s. That actually was more like international protection, where countries would basically honor each other's intellectual property rights, and that's something the United States chose to ignore for another 100 years. We did not actually sign on to the major convention that recognizes works in other countries for 100 years after everybody else.
What did that mean then, that they hadn't signed on?
Well, basically back then we weren't really producing a whole lot. We were just stealing a lot of other people's works.
So if you don't have a law, then it's okay.
Exactly. We didn't have laws to protect, and the laws we had starting in 1789 were very loose, and you had to meet very strict formalities, and you had to be a U.S. citizen, and it made it very easy for us to steal works from Europe. But over time, we wanted more protection, and we started actually developing our own cultural works, and we wanted more protection. So that at some point we decided, yeah, it's probably a good idea to grant protection, grant reciprocal rights, grant non-U.S. citizens the ability to have their works protected here, and that grew over time.
When you say we, are you talking about the individuals who are creating these works, or are you talking about, as a society, we wanted that?
We as a society, our government decided, and we are our government, the idea of we should be protecting not just our works a little more, but we should be protecting the rights of foreign authors and artists and inventors, because we want our protection, those countries to recognize are exclusive rights as well.
This situation that you were referring to before the United States signed on, this sounds very similar to what is going on in Asia right now with a lot of DVDs, isn't it?
To some extent, yes. To some extent, no. They also have issues involving what's known as the rule of law, where they may have the laws on the books, but they're not really enforcing them.
So these countries may actually have reciprocal agreements with the United States, but they don't really care because they're making money selling E.T. or Jaws or whatever movies that they're currently reproducing.
To some extent, yes, and to some extent, no. Remember, our laws end at our borders. So nothing is stopping somebody from making their own bootleg DVDs and selling them in another country unless there is a law in that country that prevents it. They can't rely on U.S. copyright law, and they do rely to a large extent on these agreements with our government, but some countries have no agreements. Some countries have no intellectual property law. And you go by the laws of those countries, and they are not members of any convention, any international treaty. They can do whatever they want. They just can't import it here.
I see. The Disney company, an American company, seems very aggressive in its desire to protect its property.
It's a very valuable property to protect.
So what has the Disney company accomplished in the law over the last, say, 50 years?
I don't know in terms, I mean, there's a lot of speculation that they were behind the increase in the term for copyright, but that is just pure speculation. Supposedly they claim that the extra 20 years extension was to protect Mickey Mouse for another 20 years, whether that's true or not. Mickey Mouse has a lot of other protections, such as through Trademark, that whether or not this was actually necessary, a lot of scholars tend to say not really.
Let's just back up a second to what you said. So we're going to go back even a little further. When copyright came to the United States, it was for a relatively short period of time that authors were granted exclusive rights, right?
Well, it's not so much it came to this country. Our Constitution, when it was written, said Congress has the right to protect works for a limited period of time, to give the authors and the inventors the rights for a limited time, the exclusive rights to their works. Congress, in that very first law, said you get 2 terms for 14 years each, a grand total of 28 years. So the first Copyright Act of 1789, that is what the term was. And you had to meet certain formalities. It had to be registered with the Copyright Office before you published it. It had to have notice. It had to have a copy on file deposited with at that time, I think it was the post office. So there were certain requirements that had to be met for you to have your rights protected, but there were also, at that time, common law copyright for unpublished works. Basically the idea that your personal writings are yours and you have the right to them, and if you choose not to publish them, they're going to be covered by common law and state copyright. That's gone now. In our current law, everything is pretty much covered under the federal law. Okay.
So originally 214s, then that changed and it became?
It developed over time. The last act, the Act of 1909 and its amendments gave us 56 years total, 2 28-year terms.
Now that's changed here in the latter part of the 20th century.
Yes, in 1976 Act, which took effect January 1st, 1978, said any works created on or after January 1st, 1978 received life plus 50 years of the author. So it went for 50, once the author died, 50 years after the author's death is when all copyrighted works expired, whether they wrote them when they were 5, 18, however old they were, they all expired 50 years from the date of the author's death.
And then there was one last.
Yeah, there was the Sonny Bono, the Sonny Bono Copyright Term Extension Act that extended it for another 20 years.
So it's life plus 70.
Correct, and that is only for if there's an author, a known human author. For other works that are created, let's say a movie where it is a motion picture, it is not a human author, those will get normally 95 years from the date of publication.
I was going to say that if you are hired to do a job, the terms are different than if you just write a book all by yourself.
Well, there is something called a work made for hire. And it's a little, it's a little tricky whether or not it's whether or not you are hired as an employee, let's say, to write a book, versus whether you are merely an employee, one of many people working on a movie.
Mm-hmm. Now, as you said, it used to be that you actually had to register your work before publication, and then it was covered under this law. In the United States today, that's an entirely different situation, isn't it? Why don't you explain what people's rights have become?
Sure, and it's actually morphed from there. That was the very earlier acts. The later acts, up until 1978, you had to what was called publication with notice. Okay, you didn't have to register it right away, but you had to have that little C in the circle and the name of the person and the year and all rights reserved written there for an international reason. So it was publication with notice. If you published without notice, you lost it. And when anybody could make copies. A great example of this is the original Invasion of the Body Snatchers. They published it, they broadcast it, they put it out there, and they forgot to put on that little notice.
The notice being like the
copyright this year, whoever when it went out there, they lost it. It went into the public domain, meaning anybody could make copies of it, do whatever they wanted with that movie, because it was published without notice.
How interesting. Okay, but that's changed now.
That's changed now. Now you get protection from the moment you fix your original work of authorship in a tangible medium of expression.
That sounds like a legal definition, right?
There are some things in there, and it's very interesting because Congress never defined author and they never defined original. They just say it has to be.
Or fixed.
Or fixed. They do talk a little bit more about fixed because they talk about being fixed in any medium now known or later created. So they do a little more about fixed.
So tell us what you tell your law students then.
Oh, I don't have that much time.
Well, tell us the short version of it.
You have to be an author. First of all, there has to be authorship. And authorship is different than ownership. So I may be the author, but I may say, I am the author, but now I am giving you my work. You are now the owner. That is different from being the author. And there are certain rights that go on with that. I can give it to you for a certain period of time. I can say, you're allowed to distribute this west of the Mississippi. I can say, you can make copies, but you can't distribute them. I can do all sorts of weird things like that. And after a certain period of time, even if I say it's forever, I still have a window of opportunity to take it back. After about 35 years, I can say, hey, I'm taking it back. There's certain notice requirements and a bunch of legalese you have to go through, but I don't need your permission to take it back. I can just take it back. And that's what happened actually with Superman. One of the heirs of one of the creators of Superman were able to get their rights back. Now, the owners, is it Warner Brothers, I believe, they can still go ahead and make all the Superman stuff they want because they still own half of it from the other co-author, but the heirs of Jerome Siegel can just sit back and collect half. They get half of all the profits. So you can take it back. So that's one thing. So authorship is different than ownership. Whether something is original is important too. That'll also go into whether or not I've made an unauthorized copy or an unauthorized derivative work. But
like Greek myths, for example.
Okay.
Can this be copywritten?
They are, well, one, the myths are very old and they are ideas and they're first told down. And you cannot copyright an idea. You can only copyright the original expression of that idea. So I'm going to tell you a story, and you tell me what I have just told you. There's a young orphan who's being raised by relatives, kind of doesn't really get along with them. He finds a special weapon that only this orphan can wield and gets a mentor to help him along the way, and the mentor dies a horrible death at the hands of the great evil, and with the help of his friends, our hero orphan defeats the great evil. What story have I just told you?
All kinds of stories.
Exactly.
But that is an
idea, and that is also Greek. That goes back to King Arthur. That goes back to some of the Greek stories. That is also Harry Potter, James and the Giant Peach. That is Star Wars. All of those are original expressions of that basic idea.
Okay. So what part of it, when you actually write the script for Star Wars, that part can be copywritten?
And well, parts of it, the parts where you're talking about Han Solo and the Millennium Falcon, and the parts about, Luke, I'm your father, that's not in any of the Greek stories.
Okay.
So those kinds of things are copyrightable. The basic plot, not so much, but when you get more and more specific, those become now original expressions that are copyrightable versus an uncopyrightable idea.
Mm-hmm. You mentioned Han Solo. There's Chewbacca. There's all. Now these can be copywritten, but then they're also, we talked in the beginning. I talked about this thing called trademark. So what's the difference between, because you had indicated Mickey Mouse. When you said Mickey Mouse, you said not only is it copyright, but it's also trademark.
Well, copyright and trademark protect two different interests. Okay, the copyright, we said, protects the artistic, creative, the original works of authorship. Trademark is about protecting brands, and protecting consumers from confusion as to source or sponsorship. So when you buy your Apple computer, you know it's by Apple. And somebody cannot come and have a confusingly similar brand, so when you think you're buying the Apple, you're buying instead this other brand. So it protects both the brand equity. They're trying to build their brand and say, hey, this is Apple, and it comes with a certain level of quality that you expect from us. We want you to buy Apple. So it protects competition in that sense. And someone else can come along and say, hey, here's my computer, here's Dell, and this is my computer, and you should buy Dell because of this, and you don't confuse the two, and you know what you're buying. So one, it helps them build their brands, and two, it protects us from confusion as to source or sponsorship, about the quality of the goods, about things like that. And that protection can last as long as you are using the mark and it doesn't become generic, and you continue to make sure that others are not using your mark without your permission.
So what you just said is that the Coke can or the Coke bottle can be protected as long as the Coke company is using it.
Well, the Coke bottle is what's called trade dress, because it's a bottle, and there we have to deal with issues.
It's something different then.
It's a little different. It's also covered under the Lanham Act, but it has to do more with the shape, and what you have to there be very careful, because if you show that shape isn't for purposes of branding, but rather it's because it fits in your hand better, then that's not really, you can't control functional things. A better example, like a bicycle bottle that fits in the bicycle holder. Hey, it grips perfectly and you can pull it out easily. You cannot get protection in that because it's functional. So the Coke bottle, they've basically shown, no, these ridges on it are not functional. They are to people to look at it and say, it's a Coke bottle.
You remember the pull top on cans?
Yes.
And then now there's the pop top. Where do those fit into the scheme of protection? Those
would have to be patented. Probably, because they are functional. If you want protection for something that is functional, for something that does something, those kinds of things, that's where patent protection comes in.
Okay. The chairs that we're sitting in, they're not patentable?
They would be, except that probably the patent on chairs expired a way long time ago. If you could come up with some unique design to a chair that no one else had thought of, that is original, and to be patentable, it has to be patentable subject matter. It must be new, it must be non-obvious, and it must be useful. Basically, you say what it does, and it does what it's intended to use. It's new, it's something novel, it's something no one else has thought of, and it's non-obvious in the sense that people wouldn't look at it and say, oh yeah, of course anybody would do that. So those are the things it has to be patentable. So the chair, this particular chair, is probably none of those things.
But there are things that somebody invents something to do with computers. Now you have to send it off to a patent lawyer who then does what in the process?
Well, unlike trademark law and copyright law, those you get as soon as you, for trademark, as soon as you've used it in commerce in connection with your goods or services, you have rights to the mark. You don't have to register it. You can still file suit. Copyright, you get those rights, but in order to sue somebody, you have to register it, but you still get the rights to your copyright as soon as it's fixed in the tangible medium of expression, your original work of authorship. Patents are different. Patents are grants from the US government. They are giving you a monopoly, and in return for that monopoly, you're going to tell the world how to make your invention, how to use it, how to make it, what it is. You give that to the world, you say this is what it is, but in return for that, you get a monopoly. You have exclusive rights. You have the right to exclude for 20 years from the day you file your application.
20 years?
Yes.
And then after that?
Then anybody can make it. So you see a lot of that with the drug companies when you see all of a sudden lots of generics will hit the market because that's the day the patent has expired.
I see.
They can start making copies.
So what does it take for a drug company to be able to retain a patent, or can they at any point retain it? Like if they make a change in the formula a little bit, is that enough?
Well, it has to be non-colorable. It has to meet all those same types of hurdles that any patent would. So let's say you designed it now to be extended release. Let's say you designed it to be in liquid form instead of solid. So those kinds of changes, if they meet all the other requirements of being a patent, you would now get a patent on, let's say, the extended release. That still wouldn't stop people from being able to practice the expired patent without using that, that extra patent, that improvement on the patent. But then again, someone else could come along and come up with their own improvement on it and patent that improvement. And so that's when you get what are called patent thickets, when different companies build on each other's patents and kind of block each other, so they reach an agreement to say, okay, we'll all give each other licenses to use each other's patents.
But this was all, as I understood it, patents and copyrights were actually supposed to be for a limited period of time, and then things were supposed to go into what was called the public domain.
Yeah. Public
Explain
domain.
This public domain.
Sure. Public domain means everybody in the country owns it, anybody can copy it, anybody can practice that invention. So that's what public domain means. We all own it. The public owns the rights to make copies to practice the invention.
Is that the American people or the world people?
In this country, I'm sticking with laws at our borders.
Okay.
Our laws end at our borders.
Right.
So different, I'm not going to, some countries yes, some countries no, I'm not going to get into that. It's within our borders. Once the patent has expired, anyone can practice it.
Now, while something is copywritten, there's something called fair use, which a lot of people on the internet make big use of, or at least they think they are. Why don't you describe what fair use is supposed to be and what these youngsters on the internet are actually doing?
Well, fair use is this idea that even if this is normally covered by one of the exclusive rights the copyright owner has, the right to make copies, the right to make adaptations, distribution, public display, public performance, some certain specific rights for sound recordings, fair use says that even though normally it would be infringement, we're allowing this use because it benefits the public. Or it may even be something that our First Amendment allows to have happen. And a great example of that is parody. Okay, we have parody.
I was just going to ask you about that.
Parody is the idea you're making a statement about something and you need to use it in order to make that statement. For example, there's the song Barbie Girl about the Mattel Barbie. Well, they're making a statement about Barbie in society. They can't talk about Barbie without using Barbie.
So would Barbie be like a trademark or a copyright?
It would be both.
Okay.
It would be both. You can be covered by both.
Barbie is a protected name.
Barbie and the shape of the doll and the look of Barbie is, people see it and they recognize it as Barbie.
Okay.
That's what makes something a brand. You recognize it as belonging to Barbie. Okay, which is where it gets part of its strength. It's also a sculpture, a non-functional sculpture of this woman, and et cetera, et cetera. It's Barbie, the doll itself, is also copyrightable.
But you're saying that there are times that someone who's not authorized can use that?
Yes. So if I'm making a statement about Barbie, if I want to have artwork that shows Barbie in a blender or S&M Barbie or things like that, I'm using Barbie as a statement. And I can use as much of Barbie as I need in order to make the statement about Barbie. This also goes to other things in terms of fair use, such as for trademark law, if I want to, let's say I own an auto shop that repairs Volkswagens. I'm allowed to say I repair Volkswagens without infringing on Volkswagen's mark. I can't use their logo. I can only use as much as I need to convey what I do, so I can say I repair Volkswagens.
I hadn't thought about that,
yes.
Because Ford, Chrysler, all those are registered trademarks.
Yes, and they don't have to be registered, but they're marks, and they're well-known marks. I can say Coke beats Pepsi in a taste test. I'm truthfully describing Pepsi and Coke based on my taste test. I can say I sell Pepsis. I can sell my Tiffany jewelry on eBay and call it a Tiffany bracelet, because that is what it is. I'm truthfully describing it. That's trademark fair use. Copyright fair use is a little trickier in the sense that, and trademark has its own trickiness, but copyright, it has to do with the idea that this is a use that based on how you're using it and how much of it you're using it and the market, and there's basically a 4-part test that is very fact specific that you go through to say, is this considered fair use?
And in the last 2 minutes here that we have, what is not fair use? And specifically, I'm talking about file sharing, and I guess it's called torrent or...
Yeah, copying someone else's work is not fair use. If I am downloading a file, it is not fair use. If someone else has the rights to decide who gets to make a copy.
So when you go to the internet, you find a movie that's just coming out or came out 5 months ago, most likely you should be paying for that?
Yes, you should be paying the authorized seller. And the internet has opened up lots of things. Now, for example, let's say I go to a swap meet, or I see someone online who's selling me the DVDs. And they've bootlegged the DVDs. And I send them my money, and they send me in the mail the DVD. I have not infringed on anything. I have not infringed on the reproduction right. I have not infringed on the adaptation, the distribution, the public performance, public display. All I've done is received a DVD. The person at the other end is the person who has infringed. That's different than downloading it. When I download it, I have made a copy. So now I am infringing.
Okay, so if I buy a book at Barnes & Noble, I have permission to resell it to you?
It's not so much you have permission. The law says that once the author has made that first authorized sale, you may sell or display that particular copy. So you have the right to do whatever you want with that particular copy. You don't have the right to make copies of it, but you do have the right to take that book, and that's called the first sale doctrine, and sell or give away or burn that particular copy. You may display that particular copy on a shelf in your office for the world to see.
But you can't
make
photocopy it and then put it out on the internet and have everybody see it.
Correct.
Okay.
That is now, what have you done? You have made a copy.
Right. That's it. Time goes by fast here. I want to thank you very much for covering a very long subject in a very short period of time. Thank you for being so brief. And I've been speaking with Professor Yvette Liebesman. She's a professor of law at St. Louis University. She teaches intellectual property. You heard what she had to say. It was pretty interesting. If you want to share it, go to YouTube and send them the link. You have my permission. Thank you.